Um, good afternoon, everyone, and hello on this rather hot day. Welcome to this webinar, One Chancery Lane webinar on the topic of the Animals Act 1971. By way of very brief introduction for those of us who do not know us, Thomas Yarrow is the co-speaker today. We're both members of the personal injury team at One Chancery Lane, which is led by our colleague Laura Johnson. My own practice has a pronounced cross-border or travel bias, and so most of the cases that I deal with, most of the animals cases I've dealt with, have concerned the exotic rather than the domesticated species. In recent years, lions, camels, Cape buffalo, dolphin, and at present, and still ongoing, a case involving a charging elephant in Tanzania. Thomas Yarrow, who, as I say, is my co-speaker and is very kindly going to work the slides this afternoon for me, was called in 2018. In a former life, he was a civil servant and latterly a UK government lawyer, where his work involved, among other things, provision of policy advice on the Brexit withdrawal agreement, something that will probably make the complexities of the Animals Act 1971 feel like a breeze. Our topic this afternoon reminds me of an anecdote which is contained in the memoirs of a recently retired circuit judge, before whom I appeared on a number of occasions. And the memoirs were lent to me, the book was lent to me by a Chambers colleague who'd also had the privilege of appearing in front of this judge. And this judge's interests were, I think it's probably right to say, more county than urban in orientation. And the anecdote he gives is at a dinner party, a local dinner party, he was asked by the elegant lady sitting next to him, stuck for conversation, what he did for a living. When he replied that he was a judge, her immediate reply was, "Dogs or horses?" We're going to be speaking to you this afternoon about dogs and horses, and indeed a little about cattle as well. Horses first from me, before I hand on to Thomas for matters canine. A couple of housekeeping matters before we get going. The first thing to say is that there's a fairly extensive briefing paper to accompany this webinar and the slides that you'll see on screen. That briefing paper will contain all of the citations for the cases that we're going to refer to. And so please don't feel that you have to scribble furiously as we're speaking. The briefing paper will be emailed out to you, we hope, later this week by Emma Williams from Chambers. So, as I say, you should hopefully get it later this week. Second, we are, both of us, content, time permitting, to answer questions or to read out any comments you have at the end. If you have notes and queries of that kind, can you please enter them in the Q&A box at the bottom of the screen rather than using the chat function? We'll try to pick them up at the end if we have time, and if there are any. We're aiming to speak for about 45 minutes or so, allowing some time, as I say, at the end, and more importantly, enabling everyone to get away to lunch on time. So, Tom, can we please have the first slide? The common law framework on which the Animals Act 1971 was so superimposed was ancient. Indeed, it dated back in this jurisdiction to the medieval writ of scienter, the earliest specimen of which I think was found dating back to 1362, although the writ would certainly have been in use before that. And the basis of this writ, this cause of action in common law and in common law history, was knowledge, whether, like the scriptural injunction that you can now see on the screen, the owner of the animal had sufficient knowledge of the animal's viciousness to justify the imposition of liability. Next slide, please. We've set out for you section 2, and specifically subsection 2.2 of the 1971 Act. We're concentrating, as the title of this presentation would suggest, on the non-dangerous species this afternoon. That is to say, those commonly domesticated in the British Isles, horses and dogs. And therefore, as I say, subsection 2.2 appears on the screen. And the Act introduces a form of strict liability for the keeper of the animal, subject to a number of fences that the prospective litigant has to jump to a successful finding of liability. I should say that by way of keeper, that can be the owner of the animal or the person in possession of it, or indeed both in relation to a particular animal. The Act emanated from a 1968 report of the Law Commission, headed or titled Civil Liability for Animals. And it's right to say, I think, that subsection 2.2, and in particular subsection 2.2b, about which I'll say more in due course, has not attracted altogether universal praise. About 20 years ago, Lady Justice Hale, as she then was, gathered together in the course of a judgment that she gave in a case, a number of the judicial descriptions and critiques of the Act and its drafting as they'd appeared through the various cases. And such comments included, quote, very cumbrously worded, quote, remarkably opaque, quote, somewhat tortuous, quote, oracular and opaque. That was one of the kinder offerings. And more recently, Lord Justice Maurice Kay has described the drafting of subsection 2.2 as, quote, grotesque. So there's been a sort of something of an arms race in the judicial scramble to throw brickbats at the law commissioners who and their parliamentary counsel who drew this thing up. And the difficulties have been this in terms of the drafting in very headline terms. First of all, the focus on the severity of the damage that's required by subsection 2.2a and the requirement of likelihood in relation to both limbs of subsection 2.2a, the sort of foreseeability component of the strict liability, and then also the interrelationship between subsections 2.2a, as you see them on screen, as you see it on screen, and 2.2b. And in this regard, the leading case of Merva Hady, in that case, in the course of his judgment, Lord Nichols pointed out that on the one hand, subsection 2.2b will be satisfied whenever the animal's conduct was not characteristic of animals of that species in particular circumstances. But subsection 2.2b will also be satisfied when the animal's behaviour was characteristic of the species in those particular circumstances. There's a sort of curious circularity in the way that subsection 2.2b is drafted. Some of the reasons for that can be found in the sort of common law thicket onto which or through which the 1971 Act was cut. Lord Justice Jackson, in a case, a slightly more recent case than Merva Hady, a case called Goldsmith and Patchcott, referred to and endorsed, albeit obiter, that construction of subsection 2.2b that's found in Lord Nichols's judgment in Merva Hady, and has expressed the view, this is Lord Justice Jackson, that where subsection 2.2a is satisfied, then in most cases, given its breadth and what I referred to a moment ago as its circularity, subsection 2.2b will also be satisfied, which rather begs the question, what is subsection 2.2b actually doing? What does it add to the obstacle that subsection 2.2a places in the path of the prospective litigant? According to Lord Justice Jackson, not very much. Next slide, please. There we are, Freeman. I've set out on this slide Lord Justice Etherton's attempt to grapple with the complexities of subsection 2.2. Freeman is the first of the horse cases that I'm going to take you to. This was a case brought against the riding stables by a claimant who was herself an experienced rider and took a horse called Patty, a 15 hands high chestnut mare, out on an escorted hack on Chobham Common. In the early part of the hack, Patty threw in a couple of cheerful bucks, which the claimant was able to sit. And when asked whether she was content to carry on, to continue with the hack on Patty, she answered that she was. The ride then made collectively the transition from trot to canter. And as Patty picked up the first couple of paces in canter, she threw in a couple of more challenging bucks, during the course of which the rider, the claimant, was unseated, fell and suffered an injury. The claim failed at trial. The judge concluded that it could not reasonably be expected that Patty would buck with such ferocity that the claimant would fall. The evidence was that Patty had only bucked in a minor way. She was a forward-going horse, but she'd only bucked in a minor way before the claimant's hack. It may be useful at this point to remind you that there are two limbs to section 2.2a. The first is the limb relating to damage which the animal was likely to cause, so if you like, likely injury. And the second limb is as it were, unlikely injury, but where such injury results, it's likely to be severe. And the judge's dismissal at first instance of the case on the basis that it was unlikely that Patty would buck in such a way as to cause the claimant injury was held by the Court of Appeal to deal only with the first limb of subsection 2.2a. And there was some criticism of the judge's judgment in not going on to deal with the second limb of subsection 2.2a, namely the likelihood of severe injury, which provided an alternative route to a liability finding against the defendant. In this regard, and as to the likelihood of the severity of damage or injury, Lord Justice Etherton, who delivered the leading judgment in the Court of Appeal, said this: first, that likely in this context in subsection 2.2a means, quote, reasonably to be expected. In reaching that conclusion and that construction, he was following the earlier decision in Merver-Hady. But as to Patty the horse's bucking, he concluded that it was, quote, obvious and therefore self-evident that, quote, if a horse bucks on beginning to canter so that the rider falls off, it is reasonably to be expected that severe injury will result. Pausing there for a moment, it seems to me that this is not obvious or self-evident at all. Most falls from bucking horses, or at least in my admittedly anecdotal experience, modest, like to result in any modest or minor injury, something akin to the bruising of ego, rather than the breaking of bones. But despite the fact that she got through subsection 2.2a, the Freeman claimant's claim was ultimately dismissed on appeal, largely because of the trial judge's conclusions on the two limbs of subsection 2.2b against the evidence presented in the case. As to the first limb of subsection 2.2b, there was no evidence before the court at trial that bucking is not a normal characteristic of horses in general. And as to the second limb, there was no evidence before the court that it was normal for horses to buck when transitioning into canter. Again, one might regard those as somewhat surprising conclusions, but I suppose it proves the old adage that a judge can only decide the case on the basis of the evidence before him. The trial judge may not have been an experienced horseman, is unable to take judicial notice of these things, and if the claimant has not troubled themselves to put before the judge evidence to satisfy the subsection 2.2b requirements, then a dismissal of the claim is likely to follow. For good measure, the Court of Appeal concluded on the appeal that the claimant in Freeman was an experienced rider who wanted, indeed had requested, a forward-going horse and had been unfazed when Patty had thrown a modest buck at the beginning of the ride. In those circumstances, it was held that she had voluntarily assumed the risk, and therefore the statutory defence contained in subsection 5.2 of the 1971 Act also stood in the way of a successful action. Next slide, please, Tom. So subsection 2.2a, the meaning of likely, as I pointed out already in Merva Hady, likely has been treated as meaning reasonably to be expected. And the horse cases I've set out for you on the slide have followed suit in that construction of the word likely. I'll just pick out for you Lynch and Ed Walker Racing. This was a case brought by a stable lad in Newmarket who was riding out in a string of 9 racehorses for the purposes of morning work. The lead horse spooked at something scary in the hedge, and what often happens in these circumstances, which is that every horse reacts accordingly in a domino effect, specifically reacting by spinning around, having spooked at the whatever it was in the hedgerow. The claimant's horse spooked, whipped round, I think in more than one direction, and then lost its footing on an adjacent bank, which resulted in a fall for the claimant and an injury. The claimant failed a first instance in the county court, and there was an appeal that came before Mr. Justice Langstaff. And the concentration in the judgment on appeal is on the use of the word likely, where this appears in subsection 2.2a, and specifically the second limb of subsection 2.2a, which is that the injury likely to be severe. Mr. Justice Langstaff accepted, following earlier authority, that likely meant reasonably to be expected. A mere possibility of injury was not good enough. But the concentration, the focus of the judgment is on the degree of specificity that is to be brought to bear in considering the foreseeability component, the requirement of likely severe injury, and specificity in the context of the circumstances of the individual accident, whether the circumstances of the individual accident ought to be considered in deciding whether severe injury was reasonably to be expected. And there was reference in this regard to the case, the earlier Court of Appeal case I've just taken you to, the Freeman case, and Lord Justice Etherton's proposition that it was obvious that a fall from a bucking horse was likely to be severe. Mr. Justice Langstaff, in Lynch's conclusion as to the second limb of subsection 2.2a, was coloured by the facts of the accident, which is to say that injury caused by falling in the way that the claimant did, as the horse whipped around and lost its footing, was unlikely. That in those circumstances, that disposed of the first limb of subsection 2.2a, namely whether any injury was likely. And it was held that a severe injury in those individual accident circumstances was even more unlikely, which disposed of the second limb of subsection 2.2a. And therefore the fact of the accident and that there was a severe injury that the claimant in Lynch had actually suffered was not enough to take the case through the gateway of subsection 2.2a. Something more than that was needed, whether it be found in statistical data dealing with horse riding accidents or the opinion of an expert witness, but certainly something more than the facts of the accident and the severity of the claimant's injury on the incident occasion was required. Next slide, please, Tom. So we come to section 2.2b. The wording of subsection 2.2b, referring as it does to normally, the likelihood of the damage of its being severe or of its being severe was due to characteristics of the animal which are not normally found in animals of the same species, or not normally so found except at particular times or in particular circumstances. It's been held again at Court of Appeal level in the Goldsmith and Patchcott case that you can see on the slide, that normally in this context means conforming to type, and that construction of that word has been followed in subsequent cases. The second limb, and as to the second limb of subsection 2.2b, which is the likelihood of damage or its being severe, is not normally due to characteristics of the animal which are not normally so found except at particular times or in particular circumstances, was considered in a case called Welsh and Stokes. In Welsh and Stokes, the horse reared up when it was being ridden through a crossroads. This again reached the Court of Appeal. Lord Justice Dyson in Welsh and Stokes held that horses do rear up from time to time in particular circumstances or when exposed to particular stimuli, and it was immaterial that the horse in question had not reared up in this way before. So one sees from that case the potential breadth of subsection 2.2b, and that cases that make their way through the gateway of subsection 2.2a can quite often also satisfy subsection 2.2b. The horse in the picture that you can see on the slide is wearing a bitless bridle, and the horse in Turnbull and Warriner, a mare called Gem, was also wearing a bitless bridle. And in this case, in Turnbull and Warriner, the claimant was riding Gem for the first time without a bit, and after a schooling session in the school, in the sand school, took the horse for a canter up the field. Gem took off, could not be controlled, went through a hedge and then dumped the claimant on the floor, the claimant suffering injury. It was held, albeit with a degree of reluctance, when the case reached the Court of Appeal, that the proper approach to subsection 2.2b was as follows. The fact that the animal's behaviour, although not normal behaviour for animals of that species, was nevertheless normal behaviour for the species in particular circumstances, does not take the case outside subsection 2.2b. So again, one sees the breadth of subsection 2.2b, the effect that it catches most cases. It was a characteristic, so it was held, of horses fitted with unfamiliar tack. In Turnbull and Warriner, the bitless bridle, that a horse fitted with such unfamiliar tack might fail to respond to the rider's aids. The case therefore fell within subsection 2.2b. Ultimately, however, on appeal, the case failed. Turnbull and Warriner, the claimant's claim failed, because again, she was an experienced horsewoman, had actually suggested that she take the horse for a canter up the field after the schooling, and knew the horse was wearing a bitless bridle for the first time, and in those circumstances it was held that she had voluntarily assumed the risk of injury, and the statutory defence in subsection 5.2 of the Act therefore operated. Williams and Hawkes is a case involving, this time not a horse, but a Charolais steer, which escaped from a field by jumping, somewhat astonishingly, a 6-foot high fence, and then made its way onto a dual carriageway after first negotiating a number of banks and other obstacles en route. When it reached the dual carriageway, it galloped along and eventually collided with the claimant's car, causing the claimant injury. And the submission for the defendant, the keeper of the steer, was that the Animals Act required a causal connection between subsections 2.2a and b, and therefore, so it was said, there was no basis for the court to conclude that the collision had been caused by characteristics of the steer which are not normally so found in animals of the same species, or not normally so found, to use the statutory language, save in particular circumstances. It was held in this case, in Williams and Hawkes, that the damage suffered by the injury suffered by the claimant was not just due to the size and weight of the steer, which is the subsection 2.2a question, but was also due to its behaviour when spooked, that is to say, exposed to particular stimuli and caused thereby to panic. And essentially, so the court held, that was enough to satisfy subsection 2.2b and to result in a finding of liability. Next slide, please, Tom. I'll deal with this rather more briefly. Subsection 2.2c, which is the knowledge requirement being that those characteristics were known to the keeper. This can be satisfied by the keeper's knowledge as to horses as a species, not necessarily being limited to knowledge of the characteristics or propensities exhibited by the individual horse. There's some discussion of that, which I'll simply give you reference to, but is dealt with more in more detail in the briefing that we'll send out in the cases of Welsh and Stokes and Turnbull and Warriner that I've also already mentioned. Next slide, please. The statutory defences are contained in section 5. Subsection 5.1 reads, a person is not liable under section 2 of this act for any damage which is due wholly to the fault of the person suffering it. The key word there, of course, is wholly. It's therefore not contributory negligence in subsection 5.1 as we know it. It's almost like a continental exclusive fault doctrine. And there aren't many cases where the injury will be wholly due to the fault of the person suffering it, and therefore a fairly restricted application. Subsection 5.1. Subsection 5.2 I've mentioned to some extent already in the cases that I've referred to. This reads, a person is not liable under section 2 of this act for any damage suffered by a person who's voluntarily accepted the risk thereof. This is not as difficult for a defendant to rely on as the common law Valenti non fit iuria defence. The cases emphasise that the statutory language is to be applied as is, and the court should not be whittling away the force or the protections of the act by applying common law Valenti principles. And the courts have often, as I've suggested, have often dismissed claims brought particularly by experienced and competent riders by using subsection 5.2 defence. It's quite a good way for a court which doesn't like the look of a claim to avoid detailed analysis of the complexities of the act. Jones and Baldwin, which is a case involving a horse show producer who was kicked by another animal, is a good example of subsection 5.2 in action. That was a first instance decision in the Cardiff County Court. Another good example is Bodie and Hall, which involved a groom, an experienced horsewoman who was balancing the back of a pony in trap, sitting on the trap at the back when the pony bolted. Again, the risks attendant upon that sort of activity. So the court held at first instance as a High Court decision, Bodie and Hall justified the application of the statutory defence. And I've set out for you there under Goldsmith and Patchcott what the Court of Appeal said in that case, which is that there's no, if you like, wagon mound type approach to the level of foresight required on the part of the injured party before the statutory defence can kick in. The final thing I was going to refer to is a short passage from the first instance judgment in Turnbull and Warriner, which was approved by the Court of Appeal when the case went there on appeal, which perhaps emphasises the difficulty that claimants face, particularly if they don't rely on a very competent and capable expert in presenting these cases to the English courts. Because the starting point for the judiciary, I think, is often this, and this is the passage from the first instance judgment in Turnbull, as I say, approved on appeal. Quote, riding is a pursuit involving the control by a rider with the aids of rein, leg, seat and crop of a horse with its own mind and physical attributes. That relationship and activity involving two living beings cannot be precisely predicted or judged to the second or centimetre. The occurrence of an accident in such a manner as I found is precisely the risk and type of risk which a rider undertakes. I mean, that's the way in to the operation of the statutory defence under subsection 5.2, and is the final obstacle that many of these cases face. Over to Tom. Thank you very much.
Thanks very much, Matthew. I'm going to talk a little bit about dogs, just picking up on a lot of those themes from what Matthew was talking about with horses and cattle. if we take the subsections of section 2 in turn, and start with the first, bite cases, there are two, I guess I should start off by saying there are two principal ways in which one can be injured by a dog. The most common one would be a bite. Second most common one would be some kind of knockover. Dog charges into you and knocks you clean off your feet, etc. The bite cases tend to focus on the second limb of of subsection 2.2a, the likelihood of severity of injury, because it's slightly easier to get through that hurdle, at least at the first stage in the subsection 2.2a stage, than it is to get through the damage likely to be caused. And the reason for that is that in dog bite cases, courts seem to have been fairly ready to accept that it's going to be a severe type of damage without really analysing the injury in too much detail. So in some example cases of dog bites, we have Cummings and Granger, where there's an Alsatian dog roaming a yard. The trespasser comes into the yard, Alsatian bites. In that case, it was simply said, well, this was an Alsatian. It was obviously going to cause a severe injury. If it was going to bite, that injury was going to be severe. Similarly, in Curtis and Betts, the dog there was a bull mastiff. It was being moved to the back of a Land Rover by its keeper, and it got aggressive with the passerby and bit them. And again, when it came to analysing the likelihood of severity of the injury, the Court of Appeal essentially just approved the judgment of the court below and said this was a bull mastiff. If it was going to bite, that bite was going to be severe. So the reason why normally in bite cases you get through the first hurdle in subsection 2.2a very quickly is because those two qualifying words, that likely and that severe, although both might have a range of interpretations available to them, what is likely, what is severe, both have been interpreted by the courts at almost the bottom of the possible ranges available to them. So civil law practitioners will be familiar with likely being used generally as a kind of balance of probabilities type word, more than 50% chance. Well, the courts have said, as Matt said in his talk about horse cases, reasonably to be expected, which is clearly if one's putting a probability on it, a less than 50% chance. And in Smith and Anger, which is a dog case that I'll return to, it was said that likely there went might or might well, much lower threshold than 50%. So that qualifying word likely doesn't mean more likely than not, means, as Matt says, reasonably to be expected or might well happen. So it's fairly easy to get through that with a dog bite, as I say. And in terms of severity, again, Goldsmith, the case that Matt talked about earlier, Lord Justice Jackson in that case essentially looked at the word severe there and said, well, most animal-related damage which somebody's going to want to sue about is going to be a severe type of damage within the meaning of the word in that statute. So that word severe doesn't mean a sort of major injury as might be set out in the JC guidelines, multiple fractures or, severe hemorrhaging from a dog bite. It just means the kind of damage which someone wants to sue about. So when it comes to dogs, as I say, Alsatians, bull mastiffs were basically self-proving without any need for much more analysis. Smaller breeds, potentially there's room there for a defendant trying to defend one of these claims to saying, well, this Chihuahua was not going to cause damage which was likely to be severe, even though those thresholds are relatively low. Difficulty with that is, of course, if a bite, even from a Chihuahua, if it punctures the skin, the official guidance from the NHS is to get medical attention for it, because of course you've got bacteria living in dogs' mouths that can mean that, you know, bites your hand, pierces the skin, starts bleeding, you could end up with some kind of nasty infection. And it might well be said, and even in the smaller breed cases, that that infected laceration, which would clearly be a severe injury in that case, or severe damage, is going to be likely when a dog bite punctures the skin because of the bacteria existing in dogs' mouths. That's probably a question for an expert to advise on. As Matt says, you need evidence in all of these types of cases on behaviours. So while you're getting evidence on behaviours, you might as well get evidence on, you know, contents of a dog's saliva and bacteria and things like that might well cause an infected cut. I think I accidentally went back a slide there. Yes. The other type of case, dogs that I mentioned, are the sort of knockover, the buffet cases where dog charges into person and knocks them clean off their feet, can result in your broken bones, banging your head on the curb, lacerations to the head, concussions, etc. When it comes to thinking about the first part of the subsection 2.2 test, part A, and severity of damage, well, Smith and Anger is a case involving a knockdown. In Smith and Anger, the claimant was walking their dog and the defendant was walking his dog, an Alsatian crossbreed, and they were crossing, I think, a road from opposite sides. And as the claimant was crossing the road from his side and the defendant was crossing from his side, the crossbreed Alsatian lunged towards the dog, so not the human, but lunged towards the dog, the claimant's dog, in an attempt to attack the claimant's dog. One can imagine if one's a dog walker, seeing such things happen relatively frequently. And in lunging for the claimant's dog, the Alsatian, which was a pretty big dog, knocked the claimant clean off his feet, broken bones followed. And when it came to subsection 2.2a, and the two limbs of that part of the subsection, the Court of Appeal effectively allowed it through the gates on both parts, said this was the type of damage which the Alsatian, unless restrained, was likely to cause. The Alsatian was in fact on a lead at the time. It's just that the defendant couldn't control it when it lunged for the claimant's dog. It was too powerful, overcame the lead. I think the defendant himself fell to the ground in trying to, you know, restrain the dog. But the Court of Appeal said that both parts, in fact, of subsection 2.2a were satisfied. This was damage which was likely to be caused, and even though it was a kind of buffet or a knockdown, rather than being a bite case, the damage was likely to be severe within the meaning of subsection 2.2a, because it was caused by a large dog such as an Alsatian. And in that decision, the Court of Appeal referenced the previous example cases of Cummings, which I've referred to, and Curtis, and expressed a reservation about that interpretation of the word severe. Said, you know, if we were just thinking about this word in isolation, in how it means what it generally means in the English language, I'm not sure it would be classed as a severe injury. But because of Cummings and Curtis, which have essentially just said big dog, likely severe injury, the Court of Appeal followed that analysis and said, well, also in a buffet case, big dog, likely a severe injury. So subsection 2.2a comfortably satisfied in all three of those cases that I've referenced, the Cummings and Curtis bite cases and the Smith buffet or knockover case. So when it comes to subsection 2.2b and the behaviours part, the characteristics, as Matt's already talked about, the key case is Mervahidi, And although that's a horse case, Lord Nichols in that case helpfully considers the second part of paragraph 22b with reference to a hypothetical scenario of a dog guarding its territory or a bitch protecting her pups. And in those cases, essentially, we're looking at the second limb of subsection 22b, which is the characteristics which are abnormal except in particular times and at particular circumstances. So the particular times and circumstances that we're talking about when looking at dogs cases are rather helpfully set out for us by Lord Nichols and Mervahidi, which are most commonly dogs guarding their territory. That seems to be the most common occasion when you're going to get a dog bite type of case, or where a bitch is protecting her litter. Less common, I imagine. I've not seen an example case of a female dog protecting her litter of puppies and biting in those circumstances. The most common is, of course, a dog guarding its territory. So that's the second part of the 22b requirement. Dog cases, dog bite cases are also going to occasionally fall into the first part of the 22b analysis, which is where the dog itself is abnormal. And again, Lord Nichols in Mervahidi says dogs generally are docile. And so if a dog does display biting behavior and that biting behavior is normal for that dog, then it almost always would follow that that is an abnormal characteristic of that dog when compared against other dogs of its type. So if you have just a characteristically bitey dog, you're probably going to go through the first limb of subsection 22b. If you've got a docile dog or a normally docile dog, but that will display guarding behaviors or aggressive behaviors when at particular times and in particular circumstances, then you're going to go through the second limb of subsection 22b. And Lord Nichols and Mervahidi essentially endorsed what was the Cummings and the Curtis approach, those two cases I referenced before, of interpreting the two parts of subsection 22b, and said the way in which one analyzes the second part of subsection 22b is to consider whether normally dogs are docile, but a particular breed of dog will get aggressive, will get bitey, will get barky and growly in particular times and circumstances. Now that you might think lead to a sort of expectation in dog bite cases that one or the other of the two parts of subsection 22b will always be satisfied. As in, either you've got a bitey dog who is just normally bitey, in which case that's abnormal for a dog, and that will get through the first part of subsection 22b, or you've got a normally non-bitey dog, which will get riled up and will get aggressive in particular times and particular circumstances. And that's likely true, but you always need expert evidence to allow a judge, as Matt says, you've got to judge the case on the evidence before you. So you need that expert evidence to say, well, this type of dog normally behaves in this sort of manner. It's normally placid, it's normally docile, but when it thinks its territory is under threat or when it perceives X, Y, or Z, then this type of dog is going to display this type of behavior. So you do need that expert evidence to get you over the line. And then the other thing to say about subsection 22b, again, as Matt mentioned in the horse context, is that there is also an element of causation that you have to prove as part of it. So that the likelihood of the damage or the likelihood of the severity of the damage must be due to the characteristic of the animal. So you have to show the link between the characteristic, which your expert has said is not normally found in the dog except at particular times and particular circumstances, and link that characteristic to the injury actually sustained. And so in the Curtis case, which was the case where the bull mastiff was being moved into the back of the Land Rover, there was very, very nearly a difficulty there because the judge at first instance hadn't actually made as a finding, or really hadn't explicitly made as a finding, that the identified characteristic of the bull mastiff, that it got aggressive when protecting its territory, and that territory included the back of a Land Rover. Hadn't expressly said that that territory included the back of the Land Rover. So although there was a characteristic which had been found, aggressive behavior when defending territory, it was not necessarily obvious that the back of a Land Rover counted as that bull mastiff's territory. But the Court of Appeal, when considering the judgment, managed to, as it were, get over that problem by saying, well, the judge had said that the territory might well, that was the phrase, the territory might well have included the back of the Land Rover. So I hadn't necessarily given a positive finding that it did, but said that it might well have included, and the Court of Appeal said, well, the judge wouldn't have said that if the judge wasn't intending to, as it were, make a finding that the territory included the back of the Land Rover. So it's just a word of caution. It did actually succeed that line of argument in the Court of Appeal, but it nearly came a cropper because that point about it's not just enough to identify the characteristic, one has to link the characteristic to the likelihood of injury or the likelihood of severity of injury. So that's 22B. In 22C, which is the knowledge part, Matt's already dealt with this a little bit. The knowledge doesn't need to be of biting per se. So you don't need to say, well, if the defendant might well argue, well, this dog has never done it before. I've never known my dog ever to bite another human being. And the defendant might think, well, that's a foolproof argument because you can't show that I've got knowledge, you can't get over the line. Well, that's not quite an impeccable argument because the knowledge that the defendant has can be of aggressive behaviors in general. So in Curtis, the bull mastiffs were known to growl and bark and jump up at the boundary, I think, of a nearby playground. You know, in the way that dogs do, sort of leaping up at this fence, barking and growling. And although they'd never bitten before, it was interpreted in that case that the defendant nevertheless had knowledge of the characteristic, which was the aggressive behavior. The characteristic wasn't the bite itself. That was, as it were, a manifestation of the characteristic. The characteristic was being aggressive when protecting their own territory. And because the dogs were known to growl and bark and jump up at the fence, the knowledge of the aggressive behavior was imputed to the defendant in spite of their evidence that they said, well, we didn't know anything about this. And that meant that it got over the line on knowledge. So that's an important one because you do often see in these types of cases, you do often see defendants saying, well, the dog's never bitten before. But on a little bit of inquiry, you find out, well, the dog's not bitten before, but the dog has sort of growled and barked and sort of made forward aggressive lunges and movements towards, people in the past, and that's enough. And as Matt says, knowledge can also be inferred from knowledge of normal behaviours of the breed. So that was the Welsh and Stokes case. That was the horse case. So if you know as a defendant, even that you don't know that your particular Jack Russell displays aggressive tendencies, if you're very, very familiar with Jack Russells as a breed, or just familiar with Jack Russells as a breed, and know that Jack Russells display this type of aggressive behavior, then you can be fixed with the knowledge that your particular dog, even if you didn't know about that particular dog, is also going to display the relevant characteristics, and then the claimant will get over the line on 22C. The problem here, of course, for claimants is it's incredibly difficult to get evidence from a defendant of how much they knew or didn't know about the particular dog, or alternatively, the particular breed of dog. It's very hard for a claimant to say, well, the defendant was a very knowledgeable Jack Russell keeper, if you just don't know that. Often the way things are done in these sorts of cases is through disclosure of the veterinary records. So if the vet records show, you know, aggressive behaviors towards the vet when trying to examine, or similar types of circumstances, then you can get the defendant, from a claimant's perspective, you can get a defendant fixed with the relevant knowledge. But it can be a difficult part to get through, this final limb of subsection 2.2. Just a final thing to say is that the Animals Act is not the be-all and end-all for animals cases, because it doesn't fully replace liability under the Occupiers Liability Act, or liability in common law negligence. So you can plead these causes of action, as it were, in these types of cases in the alternative to your Animals Act actions. And the advantage of cases under the Occupiers Liability Act or in negligence is that you don't need to do that final part of subsection 2.2c that I was just talking about. You don't need to get evidence. Again, I'm speaking from a claimant perspective here. You don't need to get that knowledge, that evidence of what the defendant actually knew about their dog or about the dog breed in general. It's an objective standard. It's the reasonably prudent animal keeper. In the case of Smith and Prendergast, which I've spoken about there, that was quite an interesting case. That was a case where there was an Alsatian, a stray Alsatian. Again, a lot of these cases involve Alsatians. There was a stray Alsatian which had wandered into the defendant's scrapyard and taken up a kind of residence in that scrapyard. And for, I think, 3 weeks or so, that Alsatian was living in the defendant's scrapyard, and then eventually it attacked and bit the claimant who'd come into the scrapyard. Now, the Animals Act claim is going to be very difficult in those circumstances because of this knowledge part. But under the Occupiers Liability Act and in common law negligence, because we're looking at the objective standard, the question was asked, well, what would a reasonable person in the defendant's position have done? And it was found that a reasonable person in the defendant's position would have, as it were, assessed that stray Alsatian dog's behavior and determined whether or not they needed to take some action in order to protect people, the visitors coming to their scrapyard. So because it had been there for some 3 weeks or so before the actionable injury had occurred, that was a 3-week period in which the defendant, who knew that the dog was there, should have reasonably assessed the dog, found out whether the dog was violent or aggressive, found out whether they needed to take any steps to, as it were, make their land that they occupied safe for the visitors, and they didn't do so, and they were found liable in that case. So that's an advantage of the Occupiers Liability Act type case, is that you can do that reasonably prudent animal keeper bit. A disadvantage is that you're stuck with more of a foreseeability problem. You don't have that strict liability that the Animals Act provides. And you have to establish a sufficient probability of an injury such that a reasonable person in the position of the defendant should have anticipated it and taken steps, as it were, to avoid it. So in the case of Whippy and Jones, that was a case involving a Great Dane, and there's a picture of a Great Dane there on the slide. The Great Dane was called Hector, good name for such a big dog. The defendant was walking his Great Dane in a park. He checked around him to see if there were any people about, saw that there was no one about, released Hector off his lead. Hector went charging around, knocked into the claimant, who sort of hoved into view shortly afterwards, and knocked her down a riverbank, causing her to sustain injuries. And the claimant failed in that case on the grounds that there wasn't that sufficient probability of an injury, such a reasonable person in the position of the defendant with his Great Dane should have anticipated that injury happening and should have taken steps to avoid it. So the defendant had acted, as it were, as a reasonably prudent Great Dane owner, had checked around to see if there was a problem, anyone around, and had reasonably at that point let his dog off the lead for exercise. So that's a disadvantage of the OLA type. Well, that one wasn't occupied, of course. That was a common law negligence case. And so that's the end of me on dogs. Just before we get to any questions and answers, just to quickly plug the next webinar in the One Chancery Lane series. It will be taking place on the 5th of August, which I think is 2 weeks Thursday, if I'm right in where we are in July. And that is how to get the most out of your barrister, and that talk will be being delivered by Sarah Prager and Connor Kennedy. And now I will just have a little look to see if there are any...
Tom, there was a question from Rachel Fawcett about a husky dog, which I have typed a no doubt entirely inaccurate answer to while you've been speaking. I don't know whether you can still, I don't know, as the resident dog expert, I don't know whether you can see Rachel's question and indeed my answer.
Okay, let me have a look. An employee delivering prescriptions.
There you are.
Patient not in puts a slip through the letterbox and is bitten by a husky inside property, resulting in traumatic amputation of finger. Claim brought against employer only, but dog owner subsequently brought into proceedings as part 20 defendant. Owner says no previous issues with dog. Beware of dog poster on front gate and police involved, but did not prosecute owner. Could dog owner realistically escape liability in the situation under the Animals Act? I'm not sure actually whether everyone can see the question or only we can. If not everyone can see it, sorry, I read that a little bit under my breath. But essentially, a husky bit a hand through the letterbox, and the owner has said no previous issues with the dog, although there was a beware of the dog poster on the front gate. What I would say to that is you're going to get through 22A very quick. If you're the claimant, that is, you're going to get through 22A very quickly. A husky, big dog. Courts are going to do that same analysis as we've seen in Cummings and Curtis. Big dog, always going to be a likely severe injury. So you're going to get through that pretty comfortably, I think. For the second part, you're going to need the expert evidence of husky behavior. So when it comes to characteristics of the animal, in dog cases, it's always characteristics of the breed. So you can't just say dogs as a sort of general species, if that's what even they are in kind of taxonomic terms. I'm not a sort of taxologist. I don't even know what the term would be, but I'm not an expert in taxonomy. But when it comes to type of dog, we're talking about the breed, not just dog as a general overarching species. So you would need expert evidence on husky behavior. Is it normal for huskies to display defensive, aggressive and I know those two words in some ways sound like they're opposites, but they're not really. If a dog is behaving defensively, they're often behaving aggressively. Is a husky going to display that kind of behavior in circumstances where they see their territory potentially being under threat, i.e. hand coming through the mailbox? Now, I'm not an expert in huskies. My guess would be that would be a typical type husky dog behavior, because that really is a physical invasion of their territory, a hand coming through the letterbox. And so I imagine you would get a sort of an expert that was willing to suggest that that characteristic, that aggressive behavior, was characteristic of a husky in those particular times and particular circumstances. And provided you've got that evidence, you're going to get through subsection 22B. I agree that I think the hardest thing here is going to be the subsection 22C, and getting that knowledge of the characteristic in the dog and fixing that on the defendant. So you need to be able to get evidence either that the defendant knew that the husky was aggressive in circumstances where they felt like their territory was being invaded. And again, I stress the point that that aggression doesn't need to be a bite. It doesn't need to be that the husky's ever bitten before, but it has to be that the husky has demonstrated aggressive behaviors, growling, barking, jumping up at, lunging at, whatever is invading their territory at the time. So you're going to either need to get knowledge of the defendant for that particular dog, or you're going to have to say the defendant has bred huskies all their lives, or has lived with huskies all their life. Again, very difficult to get from the defendant, because it effectively requires you to fish for information. But need to get from the defendant information that even if they're not familiar with that particular husky, they are familiar with huskies in general, and are familiar with the fact that huskies in general display that kind of aggressive behavior when they feel like their territory is being invaded. Beware of the dog poster, I think, is useful evidence, but it's probably not conclusive on the point.
I agree with all of that. I did think that the beware the dog poster was probably rather unfortunate in these circumstances for the defendant when it comes to trying to avoid the imposition of liability via the 22C knowledge route. But there we are. There was two other questions. I don't know if we've got time just to deal with those. Oh God, there's lots coming now. I'm not sure we're going to have time to deal with all of them, but the first one is, do you have any thoughts on known infections being a characteristic for dogs? For example, an ear infection, which is unknown to the owner, but the dog is touched on the head and then bites. Would this be a characteristic the owner ought to know? Dog was shaking its head. I mean, I think the fact that, as Tom said earlier, that dog's saliva contains all sorts of nasties, I think that's pretty widely known. So far as ear infections, about which the owner is wholly ignorant, I rather doubt. I think I'd be looking to pass that one to an expert, I think.
Yeah, I think I agree that you certainly need an expert on whether having an ear infection is a known stimulus for aggressive behavior. Again, I imagine it would be. I think it's probably sort of generally known that if a dog's in some kind of pain, then it's more likely to be aggressive. But you definitely need an expert to say so, because the judge is not just going to accept that as a fact without expert evidence. In terms of whether the owner ought to know about the characteristic, that will be a very difficult thing for a claimant to show. You'd have to show that the owner knew that the ear infection existed, first bit of knowledge that you need to know, and then need to show that the defendant knew that an ear infection meant that the dog was in pain enough to be aggressive. I think it's possible to succeed on that claim, but it's going to be hard to get the evidence that you need, I think, to be able to fix the defendant with the relevant knowledge of the characteristic that's going to cause aggressive behavior. As I say, I'm a dog owner, and I would say that I would probably know that if my dog's in some kind of pain, it's more likely to be aggressive, but very difficult to say.
We'll finally deal with the other, just while we're dealing with dogs. Another anonymous interlocutor. A dog runs up aggressively to a member of the public in a park. Dogs are not required to be on a leash in the specific park. The dog owner does not do anything to call the dog back, even though the member of the public is visibly and audibly frightened. The member of the public runs and the dog chases the member of the public and causes them to fall to the ground, causing injuries requiring medical intervention. Is the dog owner liable? I'm tempted to say yes, but not under the Animals Act in negligence.
I would agree with that. I think that would be,
as we said earlier, the Animals Act was a sort of graft on the common law, but didn't replace causes of action. For example, trespass to the person. That used to be relied upon in animal cases, particularly with dogs, or good old common and garden common law negligence. So I'd certainly be, if I were acting for the claimant in that case, I would be, if I were running an Animals Act strict liability argument, I'd certainly be pleading negligence alongside it against those circumstances.
I think that's right. I think what you might have, you might have difficulty under the Animals Act on subsection 2(2)(a), on likelihood of severity of injury, depending on your type of dog. So if it's a tiny dog, then you're probably not going to get likelihood of severity of injury.
I agree.
If it's a big dog, you might get it as a matter of course, but again, you'll have difficulty on potentially knowledge of the chasing behavior. I don't know, but I think the negligence case is stronger, and that would fit closer, I think, into the Whippy and Jones case. As I say, in the Whippy and Jones case, that was the Great Dane knockover case. In that case, the dog keeper had displayed reasonable behavior, reasonably prudent dog owning behavior, by looking around, making sure it was safe to do so, letting the dog off the lead. In this case, I think you would say, well, this isn't reasonably prudent dog owning behavior not to, respond to this situation, given that the member of public in the question is visibly and audibly frightened.
All right, I think we've run over. I know that questions are still coming in. We're very happy to answer questions we've not had time for while we're all on screen separately, including the question that's asked about the footpath and so forth, which strikes me as possibly giving rise to some OLA issues. But we'll come back to that if we may. By way of direct contact, you've got our email addresses. Good. Thank you very much, everyone, for watching and listening, and thanks, Tom.
Yes, thank you all.